Thank you so much for joining us. This will be a training on the District of Columbia's voluntary sentencing guidelines, specifically aimed at practitioners who utilize the guidelines as part of their everyday practice. This will be a high-level overview, diving into the application of the guidelines, finding the correct in-the-box sentence, meaning the in-the-box sentencing range, as well as the in-the-box sentence type. We will also discuss one of the most often types of questions that the Commission receives, out-of-district scoring. We'll also briefly touch on determining if a special circumstance applies and really where to find those issues in the guidelines when you come across those issues. And then at the end, we will also discuss additional training and resources available to you as you continue to utilize the guidelines as part of your practice.
All right, so let's dive in. So, what is the purpose of the sentencing guidelines? They were created to promote certainty, consistency, and adequacy of punishments. When you have two defendants who are being sentenced for similar crimes with similar criminal history, criminal backgrounds, ideally they should be receiving similar punishments. Now, the guidelines take two primary factors into consideration: the defendant's criminal history score, their prior contacts, and we'll dive into that in a little bit more detail in a moment. But the other factor is the seriousness of offense or offenses that the defendant is being sentenced for that day. Those are the only two factors. Now, the sentencing guidelines in the district are entirely voluntary. That means that judges are only obligated to make a legal sentence. Judges make the final guidelines range determination. They determine what the defendant's criminal history score is, any out of district scoring if those come up, and then ultimately what the guidelines box falls in, and if they just believe that this is a guidelines appropriate case to sentence within. Now, the guidelines are governed by a general rule of lenity. This means if there is ever a debate between two options, the lower option is always going to be chosen first. The benefit's always going to go to the defendant. So for an out of district scoring, the lowest possible scored comparable offense is going to at least initially be scored. That's not to say the higher option will not be chosen, but at least initially the defendant's going to get the benefit, and it must be proven to be the higher point value. Now, we do experience a high compliance rate in the district. So in 2022, we saw 92% of all felony sentences imposed were compliant in the box. That means both the length of sentence was what the guidelines falls within the guidelines recommendation, as well as the sentence type. But the goal is not to be 100% compliant. The guidelines cannot account for every case type, every case. That is really where the judge's wisdom comes into play. So we would never expect 100% compliance and or evaluating any reasons for departures, whether it's case specific or whether that's an offense we may need to consider rescoring.
Now, we've really broken down how to find the correct guidelines grid box into 4 steps. The first step is hopefully pretty easy, locating the offense severity group. The next step is really where we receive the bulk of our questions, determining the defendant's criminal history score. And as you know, this really varies with how easy to hard it can be depending on how many criminal convictions the defendant has and where these criminal convictions come from. The third step is taking those 2 pieces of information to find the in-the-box range and sentence type, and then also if an enhancement or special rule applies. We're going to really touch on where to find these in the manual, so you are familiar with them, but you don't need to memorize these rules.
So the first step is to find the offense severity group of the offense that the defendant is being sentenced for that day or offenses. So the guidelines have 2 grids, which you should see on your screen. We have the drug grid, which ranks all felony drug offenses in the district. And then we have the master grid, which ranks all other felony offenses in the district. Now, the most common offenses in each severity group are listed on the grids, but all felony offenses are ranked in Appendix C. It has a wealth of information. I really encourage you to dive in. Both grids operate the same way. The offenses that are considered the least severe, the lowest offense severity groups, are in the lowest tier. So that's Group 9 for the master grid and Group 4 for the drug grid. And then they move up in severity until you reach Group 1. So that's first-degree murder while armed and first-degree murder for the master grid, and distribution with a weapon of a drug in group one, or possession with intent to distribute with a weapon of a drug on the drug grid. So they work very similarly. So once you know what the offense severity group is for what the defendant's being sentenced that day, next you want to determine what the defendant's prior criminal history score is. So again, both grids work in the same manner. They have 5 criminal history score columns, which move from no criminal history to very little, all the way up to 6 points plus. This is entirely based on the defendant's prior conviction. So we're not scoring prior contacts, different pieces of information. This is prior findings of guilt. Now, this is initially researched and scored by CSOSA in the pre-sentence report. That information is then shared with the parties, and then ultimately it's finalized at the sentencing by the court.
All right. So what prior offenses types are scored? As I mentioned, only convictions or adjudications are being counted for criminal history score purposes. So these require a final judgment of guilt. So things like deferred sentencing agreements, deferred plea agreements, probation before judgments, post and forfeit, stet dockets, those are not being counted for criminal history score purposes. They must have already been sentenced, they're not pending sentencing, and they're not part of the instant event. Now, for special circumstances such as Youth Rehabilitation Act cases, sealed and expunged, those are still being counted. And if you ever have a question through any of this, always reach out to the commission. We are happy to answer any of your questions. There are also special scoring rules that I'm going to dive deeper into for lapsed offenses, if they revive, misdemeanor offenses, and juvenile. So how are criminal history points calculated? This is the chart in section 2.2.2 that's on page 8 of the manual that I highly recommend you tab as part of your everyday practice. It highlights how each offense is scored based on its criminal history group, the type of offense it is, whether it's an adult conviction, juvenile adjudication, and then also whether it has lapsed or revived. All of those factors depend on what the ultimate scoring will be.
Now, I touched on briefly that knowing whether offenses are part of the same event is an important topic. So why? So first of all, if something is part of the same event, it is either because it was committed at the same time and place or has the same nucleus of facts, and this is Rule 7.11 in the manual. So why do you need to know this? So for offenses that are part of the same instant event for the sentencing that day, the defendant is not going to be double penalized. So if something was sentenced in another jurisdiction for what is ultimately the same event, those criminal history points are not going to be awarded against the defendant because it is part of the same event. This is also something to take into consideration when scoring prior criminal history. So if the defendant pled guilty or was found guilty to multiple offenses from one event, you're only scoring the most serious offense from that event. So you need to know, are these from the same event? Is this a global plea, etc. This also can impact concurrent and consecutive sentencing rules, and that's covered in Chapter 6. Now, we really want to be clear. This is a factual determination that is initially made by CSOSA as the part of the PSR, and then ultimately determined by the court. The Sentencing Commission never delves into factual determinations. We can provide information, and we're in the manual to help you make these decisions and to guide your clients. But ultimately, if you reach out to us, we could not provide guidance whether something is the same event or not, because that is a factual determination that is ultimately left to the sentencing judge.
Now, lapsed and revived convictions. So there's a basic rule you want to keep in mind when scoring. Convictions or sentences that come from within a 10-year window before the commission, not the sentencing date of the instant offense, the commission of the instant offense are scored. Okay? So all of that within that window is scored. If you have an adult felony conviction within that 10-year window, it revives all other adult felony convictions. And I'm saying adult felony convictions specifically for a reason. We're going to touch on adult felony convictions first. I'm going to discuss misdemeanor and juveniles after. Let's just talk about adult felony convictions first. So this arrow that you should see on your screen, I love this visual because I think it really keeps in mind that that is a separate adult felony conviction from the one being sentenced. You have your offense being sentenced, you have your 10-year window, and within that 10-year window, you need a separate adult felony conviction to revive all others that are outside that window. And as you can see on the screen, these are what within the outside the 10-year window, how lapsed and revived offenses would be scored. So let's do an example and see how this comes into play. We have an instant offense that occurred on August 8th of 2021 and is being sentenced today. Now this defendant has a few prior criminal convictions. Distribution of cocaine. This probation ended on March 10th of 2015. And the thing you want to keep in mind for the 10-year window is a sentence falls within that 10-year window based on when the sentence ends. And a sentence ends when it's supervision, whether supervised release, probation, unsupervised probation, when that ends, court supervision, that's when the operative date that you want to keep in mind, not the sentence date. So in this case, the distribution of cocaine, the probation ended on March 10th of 2015, so it falls within our 10-year window. The robbery, supervised release ended in May 7th of 2011, falling just outside of our 10-year window. And we have one more. We have an armed robbery where parole finished June 10th of 1985, so significantly outside of our 10-year window. So in this case, our distribution acts as our revival offense. It falls within the 10-year windows and it revives the robbery and the armed robbery. So as we recall from that chart from page 8, the distribution of cocaine has not lapsed, so it's counted at its full point value, 1 point. The robbery, however, has lapsed, so at its revived point value, because of the distribution of cocaine, it is now only 1 point. But the armed robbery, because of its offense severity group, it is revived because of the distribution of cocaine, but it comes back at its full point value. It is 3 points, so this defendant has a criminal history score of 5 points. But let's change up the scenario just slightly. What if we get rid of the distribution of cocaine, right? We have lost our revival offense. There is nothing within this 10-year window. Now, we still have the robbery, we still have the armed robbery, but we don't have a revival offense. So while the judge is going to see this, it does not move our criminal history score. So if you have something within the 10-year window, offenses, adult felony convictions, no matter how old, are all going to get revived. But once you lose that, you lose your revival offense, these offenses are no longer scored, and this defendant went from a criminal history score of 5 to a 0 because they no longer have the distribution of cocaine. So it really makes a significant difference. So paying attention to when certain dates are really can matter, as well as whether something falls within the window. All right, so let's shift gears and discuss misdemeanors. Misdemeanors are worth 0.25 points each, or a quarter point. They have a 1 point maximum, meaning you're only counting a maximum of 4 misdemeanors no matter how many misdemeanors a defendant has. They must have a 90-day or more statutory maximum sentence. And statutory maximum is the important part you want to remember here. It doesn't matter what the defendant was sentenced to in terms of whether you're counting it. It could be a 45-day sentence. It could be a 10-day sentence. What is the statutory maximum? If it is 90 days or more, that is a misdemeanor that you will be counting for criminal history purposes. If it's a statute that the penalty is less than 90 days, it will not be scored. Now, misdemeanors cannot revive other offenses, and they themselves cannot be revived. So again, we have an instant offense that occurred on August 8th of 2021 that is now being sentenced today. This defendant has multiple misdemeanors falling within the 10-year window, but their only felony conviction falls outside. It is a robbery that ended in December of 2005. So even though they have more than 4 misdemeanors, they've maxed out at their 1 point, and since they only have misdemeanors within the 10-year window, their robbery is not revived. It has lapsed. So again, the judge may consider it, and where in the range, the sentencing range of the guidelines, they want to sentence the defendant, but it's not going to move the box for this defendant. They have maxed out at their 1 point. Juvenile adjudications also operate a little bit differently. They operate at lower point values, as you'll see again from our favorite chart on page 8. Misdemeanor juvenile adjudications are never scored, and they operate on a 5-year lapsing window instead of the 10-year window. Now, our 5-year runs either from the day of adjudication or release from a locked facility, and it must be a locked facility. If it is unknown whether that facility was locked, whether the defendant was in the locked portion of the facility, you're then going to go from the day of adjudication. Remember, the rule of lenity applies. So unless you know that it's a locked facility and the defendant was in that portion of the facility, going from the day of adjudication. Juvenile adjudications cannot be revived, and a great rule of thumb is if the defendant is over 26 at the time of the instant offense, they would have aged out of the system. So their juvenile adjudications, no matter how many they have, would not have count against them. Now, juvenile adjudications have a 1.5 point maximum for all juvenile offenses. There is an exception to this. If the defendant has multiple master groups 1 through 5 adjudications, so they have, say, 3 or 4 master group 1 through 5 adjudications, separate events, remember, and also other adjudications. You're only counting the master group 1 through 5 offenses. So it goes up 1.5, 3, 4.5. So you can increase that maximum, but you're not counting any other adjudications, if there are any. Now, one of the trickiest subjects is prior out-of-district convictions. So we'll walk through this, go through some examples, but as always, the commission is available for any questions you have, how things have been scored prior that we're aware of, really walking through this. So this is meant to be helpful, but the commission is always available to answer questions as part of this process. So out-of-district convictions are scored like the closest comparable DC code offense. And this is from Rule 2.2.5, which if you're not familiar with, I really recommend you read because it really walks through at least the initial steps of how the PSR is scored. And then ultimately you're going to be looking at it at the next level once you get into the facts. But at least initially, the initial calculation is actually based without any factual analysis. One lesser known fact about out-of-district convictions is the parties actually can agree to what the score is before the PSR is created. The guidelines have a rule against criminal history score bargaining, but for prior out-of-district convictions, because there oftentimes is not an apples-to-apples comparison, the parties can reach an agreement that Maryland robbery should be scored as 1 point rather than 2, or to give a hypothetical, to make things easier and kind of take some of the guesswork out of the plea bargaining arrangement. And then CSOSA and the court should honor that agreement. Now, if the parties do want to challenge the PSR, they do so in 2 ways. They either challenge the closely matched determination and say different statute closely matches the offense instead, or this is the time when the facts are introduced, and this is done by a preponderance standard, that the facts, the underlying facts, do not match what the elements of that offense, DC offense, are. The presiding judge ultimately makes the ultimate determination of what the proper scoring and comparable DC offense is. All right, so what is this procedure? So the first step is really just looking at the name of the offense of the out-of-district conviction on the criminal history sheet, so the NCIC, the PRISM. It can give a wealth of information, whether it was an attempt, what drug was potentially listed, the theft amount. So oftentimes there really can be additional information to try to determine what the offense is. It also may include the notated out-of-district statute, whether it was Maryland Code 3404C 1.2, etc. it can help limit down so you know what section rather than kind of comparing to a full statute if possible. You're then going to look at the title of the offense in the out-of-district statute of common law. Again, it may provide additional information to know exactly what statute you're looking for. You're then going to take all of that information and examine the elements of the offense of the out-of-district statute or common law. Now, no statute is perfect. Many will not define the elements of the offense. You'll have a robbery that says if robbery is committed, the penalty is, and it doesn't say what the actual elements of robbery is for that jurisdiction. So additional resources can be considered at the time, such as case law or jury instructions to determine what the elements of the offense is for that jurisdiction. So there are cases where there is more than one DC offense that closely matches the out-of-district offense. When that does occur, that is noted. The least severe DC offense is scored initially, and then a footnote is dropped listing the 1, the 5, however many it is, other DC offenses that the out-of-district offense could match and potentially be scored up to. What matters is how DC ranks and criminalizes this conduct. If the out-of-district offense is a misdemeanor, but the least severe DC statute is a felony, it's going to be ranked as a felony, but also vice versa. The out-of-district offense is a felony, but DC compares that to a misdemeanor, it's going to be scored as a misdemeanor. We're looking at least initially to the underlying conduct. We're focusing on the name and the elements of the offense. And that's also what's happening when the commission is giving that initial scoring. Keep in mind, the commission is not giving factual determination. So if you reach out and ask for a scoring and say, but in this case, my client did this, or I know based on the statement of charges that these were the facts. The commission does their evaluation based on the actual elements rather than on the underlying conduct. Those arguments are appropriate for sentencing. The commission stays out of these factual determinations. Some additional guidance to keep in mind, because again, I know that these are tricky. For purposes of criminal history, again, we're scoring based on the mostly closely matched DC statute, based on the name and the elements. Some match very well and are perfect almost alignment. Others, it really is either a mismatch or there may be no comparable. So it really varies with each offense and out of district, how many or how few and the possibilities. One great question we received, I think, also illustrates these issues very well. So a defendant has a prior out-of-district conviction from the same event, but again, multiple convictions, and they closely match the following DC offenses: possession with intent to distribute and carrying a pistol without a license. Remember, these are two separate offenses. The question was whether this should ultimately be scored as possession with intent to distribute while armed, right? That makes sense. Possession with intent to distribute, you know, this person also was carrying a pistol without a license. But keep in mind, this defendant did not, in this out of district, plead to that. So ultimately, they pled to this as two separate offenses. So the offenses are going to be scored to reflect the individual offenses. So the matching PWID, which is the most serious offense of conviction where there are multiple offenses arising out of this single event. So you're not, again, looking at the facts and kind of creating what it exactly matches. You're really looking at what the defendant pled guilty to. So let's look at an example. A prior conviction for a Maryland first-degree burglary. Now, in Maryland, their statute requires a person may not break and enter the dwelling of another with the intent to commit theft or a crime of violence. Very similar to DC Burglary 1, with the exception that the Maryland offense does not require a person to be in the dwelling. Now, someone might be in the dwelling, but it's not required. So the way it would be scored is it matches DC Burglary 2, because again, it does not require someone to be in the dwelling, but it is potentially possible based on the facts. So it would be initially scored as matching DC Burglary 2, with a note it could match DC Burglary 1. And again, this is when the facts would come into play at sentencing if the parties know that someone was in the home. But at least initially, it would be matching DC Burglary 2. Another common question we get are possession with intent to distribute, all the changes in marijuana laws. So if the drug is not known, it could potentially be marijuana. And the initial rule is if it could be marijuana or it is marijuana, possession with intent to distribute is not scored because it could be an amount that is decriminalized in the district. Again, the rule of lenity. We are not penalizing a defendant, at least with the higher penalty, at least initially. So if the drug is not known, this would not be initially scored. But if the PSI is going to note, it could be 1 point depending on the drug. So if it's not marijuana, this would be scored. But if we know that, say that this is possession with intent to distribute cocaine, score it accordingly and score it as 1 point. So this again is where the title, the additional information can really come in handy to really pull out some of that guesswork. All right, so we've gone through a lot of information and done a lot of work here. We know how to find what the offense severity group is and what the defendant's criminal history score is. So now we can go back to the grids and figure out what the sentencing range recommendation is. So on your screen, you're going to see an example for a robbery conviction. That's master group 6 with a criminal history score of 2. So you take those two pieces of information and you find box M6 with a criminal history score of 2, so that's box C. Bring it together, that range is 30 to 72 months for that offense and that criminal history score. Now, a sentence outside of 30 to 72 months would be considered a durational departure. The grid not only gives the sentence length recommendation, it also gives a recommendation on the sentence type. Now, there are a couple different options on the grid. The entire grid has an option of either being a prison or a long split sentence, but those are the only option on the red boxes on your screen. That would mean that the defendant initially serves at minimum the bottom range of that box, but not more than the top range incarcerated. In the yellow and green boxes, a short split is available. That means the defendant would be incarcerated for no longer than 6 months. Part of that would be suspended, a portion of that sentence would be suspended, and then it would be followed by a period of probation. Only available in the green boxes is a probation sentence where the entire sentence is suspended and the defendant is placed on probation. If the defendant is given a sentence that is not an eligible sentence type in that box, it is considered a dispositional departure. All right. So split sentences, these are another area where we often can get questions. So let's first talk about short splits. So overall, any split sentence is a sentence where the court suspends some but not all of the defendant's sentence, suspends imposition of supervised release, and imposes a term of probation, which can be unsupervised. But in a compliant short split, the defendant is only serving up to 6 months, and the overall sentence must fall within the recommended box range. So let's take the example on your screen, which is box M7B, 18 to 42 months. The overall sentence must be within 18 to 42 months, and then the executed sentence must be within 0 to 6 months. So a sentence of 20 months to spend all but 4 months would be a compliant sentence. A sentence of 20 months to spend all but 8 months would be non-compliant because the executed time would be greater than 6 months. A sentence of 12 months to spend all but 5 months would also be non-compliant because it would be below the box, less than the 18 months. Now, long splits are a little bit different. Both portions of the sentence must fall within the box. So the example on your screen is a burglary 1, an M5 offense with a criminal history score of 1. So the recommended sentence is 48 to 96 months. So for the first example, 72 months to spending all but 50 months, both parts of that sentence fall within the recommended sentencing range. 72 months, 50 months falls within this green area. But if we shift to the other option, 72 months to spending all but 24, that would be considered a non-compliant split because 24 months is outside of our green area. It's below the 48 to 96 months. So that would not be considered a compliant split. Both parts of the sentence have to fall once you're in the higher box ranges for a long split. All right. Now, the final thing you want to keep in mind is if a sentencing enhancement, a special circumstance applies. There are a lot of different rules and things to keep in mind. So what I really try to recommend is to really keep in mind that these are options and things that are in the manual and to know to look for them. So sentencing enhancements are discussed in Chapter 4 in Appendix H. Rule 11C1C pleas, which we are seeing more and more often, are Rule 5.1. Keep in mind they are always considered guideline compliant as well. Consecutive concurrent sentences are Chapter 6. Accessory after the facts. New convictions are Rule 2.1.3, but prior accessory after the fact convictions are Rule 2.2.2. Now, if a departure is given in the case, those are also discussed, whether it's mitigating or aggravating factors throughout the manual. Additional sentencing issues you do want to keep in mind. Supervised release periods, that's Appendix F. The maximum sentence that can be imposed, that's also discussed in Appendix F. Mandatory minimums, those are very important because again, the judge is required to give a legal sentence. The guidelines are voluntary, but a legal sentence must be given. So do keep in mind a mandatory minimum, Rule 3.6. Revocations are also discussed in Rule 3.8. Now, we do ask that you keep in mind, and we may reach out as well, but as part of the sentencing process, we have the courtroom clerks and all parties. It's just helpful to know that we will be documenting whether there's an 11C1C plea, mitigating and aggravating factors. So if cases trends move in different directions, we really do take a look at. So if there's a 10, a 11 departure, we do ask that the court provide a written explanation. If for whatever reason the case is sealed, there's obviously an exception for that. Some cases as well, the court does elect not to use the guidelines, so we do also get that information as well. If at sentencing, the court does update the criminal history score as well, we will also ask that that be notated. So if you have any additional information, it would be helpful for you to get this type of data as well for your sentencing. Please don't hesitate to reach out to the commission. We are always happy to help in any way. We love giving training, so if you'd like one-on-one training, would like training on a more specific topic, or just have any additional questions, we are available via email, phone. You can reach out to me specifically, and then we have a wealth of information on our website. We update with our annual report. We have a specific tab just specifically for resources for our practitioners, as well as just additional data and information. I really appreciate you taking the time out of your busy day to watch this training. I hope it was helpful, and we look forward to hearing from you.